more than 23,000 people have been deported to countries they have never called home. The U.S. has secured agreements with more than 30 countries to accept them, including one under a State Department do not travel warning. How is this happening while a federal judge has already called the policy unlawful? The number is not an official government count. It comes from advocacy tracking that monitors flights, public records, and court filings. The bulk of the transfers went to Mexico, about 20,000 people. More than 2,700 were sent to other Latin American and Caribbean destinations. Over 330 were transferred to African countries where the consequences have been sharpest, and more than 200 went elsewhere. The country that has drawn the most scrutiny is the Central African Republic. It is under a State Department Level 4 do not travel advisory due to armed conflict, political instability, crime, and terrorism. The State Department's own guidance to U.S. citizens traveling there tells them to prepare wills and DNA records. A U.S. delegation met in Bangui around May 18, 2026 to arrange the transfers with terms undisclosed. The first deportation flight arrived on or around June 12 to 13, carrying roughly 18 to 25 people, including nationals from Afghanistan, Iran, Syria, Turkey, Georgia, Uzbekistan, Tajikistan, Cameroon, Armenia, and Iraq. A second, larger flight of roughly 80 migrants, including Cubans, Ecuadorians, and Hondurans, arrived in late July and early August. The program is running against protections U.S. immigration courts grant when a person cannot be returned home. Withholding of removal is a court order barring the United States from sending someone back to a country where persecution is more likely than not. People carrying that protection are still removed to third countries, not home. So the removal order can be satisfied. An Iranian pro-democracy activist with that protection was on the June flight. Her attorney, Emily Trostel, said requests for a fear interview were ignored, and the destination was not disclosed until the day before departure. Afghan nationals whose cases have been identified are also facing transfer despite protection orders. The program is being fought in court. In February 2026, a federal judge in Massachusetts ruled the policy unlawful and imposed a 15-day stay. In March 2026, the First Circuit allowed it to proceed, creating a circuit split. As of late August, the policy remains in effect, with no nationwide injunction and no Supreme Court intervention. On June 25, 2026, the Supreme Court ruled 6-3 that the administration can end temporary protected status for Haitians and Syrians, opening the way to terminate protections for roughly 350,000 Haitians and about 6,100 Syrians. On June 5th, a coalition filed a complaint with the African Commission on Human and People's Rights against Equatorial Guinea on behalf of 14 deportees held in arbitrary and indefinite detention. On July 7th, the Iranian-American Legal Defense Fund and Public Citizen Litigation Group sued in U.S. District Court for the District of Columbia, alleging DHS illegally shared confidential asylum file details with the Iranian government. DHS denies the charge. The agreements themselves are often opaque, sometimes brought into the open only through litigation. Some came with money. The Liberia arrangement linked to roughly $124 million in assistance, and the Central African Republic deal reported in connection with $85 million in funding. DHS did not respond to questions about the CAR agreement, so what remains unresolved? One district court has called the policy unlawful. An appeals court has let it operate. The Supreme Court has not weighed in. As those cases proceed, the people already transferred live with the result, without status, without documents in countries they were never from, and with the risk that the chain of removals carries them on to the danger U.S. courts had already determined they must not face. Like and follow for more stories that matter.